Welcome back. We are continuing our conversation and legal analysis of day 5 of the Alex Murdaugh murder trial. We're still joined here by trial lawyer Carl B. Grant. Before the break, we were looking at the interrogation video the night that Alex Murdaugh was inside of the cruiser with officers, giving his account of what he saw when he allegedly arrived on the murder scene of his wife and his son. One of the things that has been the topic and the highlight of both the prosecution and defense's argument was, what was Alex Murdaugh wearing, the condition of his clothing? Why is that such an important issue?
Well, again, it goes back to the opening statements of both sides, the prosecution and the defense, particularly for the defense. The argument has always been, there's no way that this man could have done those kind of crimes with all of the blood splatter. I mean, think of the scenes that have been described, even matter on the ceiling in the building, where he was, all over the floor, all over. How could none of that have gotten on his white T-shirt? So that's the obvious argument by the defense. That is, if he would have done it, it would have been all over his clothing. And so that was a pretty good argument. Now today, you find there's an argument established by the prosecution that he admits that he touched them. He tried to turn them over. At least the son tried to turn them over and check their pulses. And well, if you did that, then once again, why is there no blood on your clothes? So both sides have the argument of what's going on here, why is there no blood? But it gave the prosecution an argument to say that this man has to be lying, or there was some opportunity for him to change his clothing. He cannot have the same clothing on and have touched these bodies the way that he did. That's going to be the thrust of their argument.
Well, and listen, there's another video that we want to show. If there's been a Perry Mason moment, so to speak, in this courtroom testimony so far, this might be it. Let's take a listen. This is one of the agents testifying and pointing Alex Murdaugh out in the courtroom. Take a look.
Is the individual in this courtroom who told you he tried to take the pulse of Maggie and Paul, is the individual in this courtroom who told you he tried to turn Paul over, told you that once, twice? Is the individual in this courtroom that you took that statement from, that we saw in this video, in this courtroom, and is the individual you described as clean from head to toe in this courtroom?
Yes, he is.
Please point him out for the jury.
He's sitting at the defense table wearing a grayish-brown jacket and a white shirt.
Your Honor, we'd like the record to reflect she has pointed out the defendant, Richard Alexander Murdaugh.
It does.
So we've talked about the implications of that testimony, that evidence, and how the defense and prosecution are trying to use it to their advantage. But Carl, speak to your assessment of the quality and character and integrity of the testimony that we have seen so far from the prosecution witnesses.
So far, the witnesses have come across as people who are telling their story, all right? And obviously, they've been prepared by the prosecutor. You don't just put a witness on there willy-nilly without finding out what they're going to say. And they've come across as just telling what they know. That's the way it seems to me.
Credible?
Well, that's for the jury to decide.
Okay.
I try my best not to step into the territory where a jury is still trying to deliberate. Let's see what the jury decides. But that's why we have direct examination and cross-examination. And going back to cross-examination, as a trial lawyer, there's this rule, we call it the 10 Commandments of cross-examination. One of those is that you don't ask a question that you don't know the answer to. And I imagine my great friend, Mr. Griffin, would say, I wish I would not have asked that one question where this witness can get it in there about, well, because the clothes were dry and he was wet. Ugh.
Yeah. and must every witness be cross-examined about the thing?
No, not every witness has to. In fact, sometimes the jurors appreciate it when you don't have any questions for the witness. And I always take the approach, if the testimony on direct doesn't hurt me or my client, why waste time? No questions, Your Honor, and I sit back down.
All right, well, the weekend here, the court will resume, trial will resume Monday at 9:30 a.m. We will look forward to more of your expert insight and analysis to help us navigate this trial and right up until we get a verdict in a few weeks, we expect. So thank you very much for your expertise.
Yes, thank you so much, Carl. All right, we're going to take a quick break and we'll be back.